Former President Jacob Zuma is due back in the Pietermaritzburg High Court today. Zuma's arms deal corruption trial has dragged on now for almost 2 decades. Now, last year, Judge Piet Koen dismissed the former president's special plea for the recusal of State Prosecutor Billy Downer. Today, Zuma is expected to ask the same court, to grant him leave to appeal that judgment. He believes the Supreme Court of Appeal might come to a different conclusion on the matter. Let's get you some analysis now. Mpumelelo Zikakala joins us via our video link. Mr. Zikakala, thanks very much, as always, for your time. I suppose, people might be thinking this morning, are you able to appeal a decision by a judge, the same judge that made that decision in the first place, but also in a case that has dragged on for as long as this has?
That's the normal procedure which is used in the legal profession, in that the court that ruled against you, that's where you're going to start and say, I believe that your elder brother or sister in a court which is higher than in which you are in will come to a different conclusion. Based on that, maybe you have made an error in terms of the facts that you have looked at, or a fact in terms of law, or in terms of saying there's greater room to develop the jurisprudence in this particular discipline that we're dealing with. And I think if we take the matter to the SCA, they'll be able to answer us and bring finality to the nature of the dispute that we're dealing with now. In this case, if you look at the cases which are leading, when it comes to charging to prosecute, I would say maybe they are less than 10 or even less than 5, which means that greater room of developing this jurisprudence when it comes to explaining and giving a much more valid explanation as to what does it actually mean to say that a person does not have a charge to prosecute.
I suppose further to that, the question is also, if the former president is indeed successful in this plea to get Downer recused, if another court does find that he is correct in his argument for Downer's recusal, what does that mean for the trial? Does it go ahead? Or, is there a set of circumstances where the proceedings could be finished?
I think this is what they seek, the former president legal team. They said, in fact, it is not only Advocate Billy Downer that does not have charges to prosecute, it is the whole NPA. Yeah. I see a bit of difficulty in the court agreeing with them in that instance, especially with the whole of NPA argument. In this sense, let's remember that we have not traversed the merits of this. It's whether a person is guilty or not. We are still dealing with the preliminary stuff or incidents or maybe allegations that are there, dealing with the procedural matters with regards to this matter. So what the court would definitely want is to say, we want to hear the evidence of this matter so that at the end of the day, we are able to come to a conclusion. Now, for us to take a drastic step of saying that the matter or the case has to be whisked away, and you don't have to answer anything just because you have one person who's a prosecutor who's alleged to have engaged in a certain manner of misconduct, it's something in which we'll not be inclined in terms of doing. But if you would say that if you remove him and another person comes in to prosecute me, then I'll be able to deal with the matter and the merits. That could be understandable. And that is basically what the court would have to do if they are granted leave to appeal and they go to the SCA. Because that would mean that the court is now adopting a wider interpretation of the charge to prosecute by saying we are not only limiting it to the administrative elements, so administrative factors of do you have the relevant qualifications, have you been granted relevant authorization by the person who's in charge. But what we're looking at is the conduct and the manner in which we've conducted yourselves in. But linked to that is this: are there any other precautionary measures that can be taken to ensure that we do not infringe your Section 35 rights? In this case, in which what the court has said in the previous occasion also said, when the trial starts, the admission of evidence, that is where we are going to test whether that evidence should be used or not, and whether the manner in which it was obtained is one which is in line with our Constitution. If it's found that there are certain transgressions that have taken place, that evidence will be disregarded. So your rights in terms of a fair trial, former president, are still protected despite the fact that either Advocate Billy Downer is still the one who's prosecuting you or not in this particular matter. So for you to come to us and say, they basically pronounce me an innocent person purely on an irregularity or in a procedural fairness point, I don't think that the court would be inclined to granting that application.
And as you say, Mr. Zikakala, it's not about the recusal of Billy Downer himself and the fact that another prosecutor could be brought in. But the argument being made by the former president's legal team is it's Billy Downer that it has a problem with, but also that the whole of the NPA is also biased.
Definitely, that's what they're saying. But then the next question would be, let's look at the preventative measures or the measures that have been put in by our law, whether it's common law legislation, to take care of instances such as those ones. And the presiding officer, being a judge, an innocent bystander whose sole task is to look at the evidence which is presented by both parties, that's the first line of defense or first act of being a presiding officer that they would take. They would say, yes, evidence has been presented to me, but I want to check, is this evidence obtained legally? Is it in line with our prescripts, especially the Constitution? Can I accept it as a credible evidence? If the case is yes, then we'll be able to continue on that one. The basic or the principle being that you must be able to come and answer to the allegations which have been made against you. And if you are found innocent, definitely the judgment is, or the court is going to exonerate you. But if you are found guilty and it has been proved beyond reasonable doubt that indeed you performed this particular act, then they are going to say, please come back and answer to your actions, and we are going to grant you the relevant sentence or sanction. So to say the whole NPA does not have charge to prosecute, I think it's a bit of a stretch, and they would need to convince the court as to why, or the basis, or especially the legal principles of saying that that should be the case.
Yeah. The former president's legal team is also arguing around Judge Piet Koen's handling of this appeals, this leave to appeal process. It says it's been procedurally irregular, that Judge Koen has misunderstood the legal matters at hand. Now, the judge, in making that decision last year, said that all of the issues that the former president's legal team brought up insofar as the handling of his case is concerned by prosecutor Billy Downer, that those issues could have been dealt with within the trial itself.
They are saying that, but you must also look at it in this manner. The only way in which you can be able to traverse all these particular arguments is within the trial. In the instance of saying, when the evidence is going to be led, then you are separating it one by one. That's where you start to say, how did you obtain this evidence? Is it obtained illegally? Is there any other influence that has been made in which would warrant that this evidence should not be considered by the court? If the answer to that is yes, then it would be put on the side. But I must say that the manner in which Judge Koen has handled this matter is let's say, is commendable and remarkable, in a sense that he has been able to silence the noise which is outside the courtroom and simply focused on the procedures in which one should handle when you are inside court. Let's also remember that you are dealing with the High Court in this matter. They have their own jurisdiction, inherent jurisdiction, by the way, which means that they do not prescribe to a strict legislative prescripts like the magistrate court. So they're able to charge their way in a manner in which they deem fit, just as long as it is in line with the rules of natural justice, and especially of that of Section 35 of our Constitution. Now, let's look at how the matter has been handled. Each party has been given, in my view, adequate notice and adequate time to make the necessary submissions. They've been heard in all instances. They haven't been silent in any matter. And the door has been open in terms of saying, come to me and try and persuade me as to why I should rule in your favor. If you can persuade me, then I'm going to rule in your favor. But if you can't, then unfortunately I'll have to say no. In which that is what they did last year, that Judge Koen did last year. Because he came back and said, I do not believe that the precautionary measures that are here, the stops and balances that have been put into our law, either legislatively through the Criminal Procedure Act or in the manner in which we handle ourselves during the courtrooms, are not going to be able to provide adequate protection of your client's rights. In this case, there are instances in which we'll be able to question even the manner in which the evidence has been obtained. If that is open, then let's continue with the trial. You would raise any other inadequacies as we move along.
Right. Right. Mpumelelo Zikakala, thanks very much indeed for that perspective. Legal analyst there joining us as we continue to track the story around Judge Piet Koen hearing arguments by former President Jacob Zuma's legal team today. Leave to appeal the dismissal of his special plea for the recusal of lead prosecutor Billy Downer in his corruption case.